You're watching Reality Check. Every day new instances of the extraordinary double standards when it comes to how the law applies to those accused of hate speech or inciting violence. The creators of the vile Bulli Bai app, which conducted fake online auctions of Muslim women, granted bail by a court in Delhi after spending around 80 days in jail. While granting bail to the creators of the hate app, the court said the accused is a first-time offender and a young person. Prolonged incarceration will be detrimental to his well-being. The accused has roots in the society. The trial would take considerable time. No fruitful purpose would be served by keeping him detained any further. However, both of them will continue to be in jail as they are facing charges in other connected cases as well. Now, it can be no one's case that the accused should be denied bail in perpetuity. In fact, the Supreme Court has said jail is the exception and bail is the rule. The problem that there's a glaring asymmetry in how this principle seems to be applied in the current context, where those seen as critical of the government or of the ideologies of the ruling establishment face far harsher penalties and end up spending much longer in jail than those who don't. For instance, Umar Khalid, student leader accused in the Delhi riots conspiracy, charged under the anti-terror law, stringent, in jail for 18 months, bail denied once again last week. What he'd said in his speech, of which the video was part of the prosecution's evidence, included comments like, when Donald Trump comes to India, we will say the government of India is destroying the values of Mahatma Gandhi. Or Sharjeel Imam, a student leader accused of speeches during the CA protest, again charged under the anti-terror law. He's been in jail for 26 months. Bail has been denied several times. He said in a speech that if we have 5 lakh people with us, we can cut off the northeast from India, if not permanently, for 1 or 2 months, which his lawyers say is him referring to a chakka jam, something which is not that unusual as a political or a protest strategy. Others are booked and arrested on what appear to be highly flimsy grounds, like Munawar Farooqi, the comedian who was charged for hurting quote-unquote Hindu religious sentiments, spent 36 days in jail, arrested for a joke he never cracked. Now, contrast this with how those linked directly or indirectly to the ruling establishment or the Hindutva ecosystem face no consequences at all, like Anurag Thakur, union minister, who despite making an inflammatory Goli Maro speech ahead of the Delhi riots, 26 months later faces absolutely no action. Or Parvesh Verma, BJP MP, despite saying these people will enter your homes and rape your daughters. Again, this was ahead of the Delhi riots and a reference to the CAA protesters. 26 months later, no action. In fact, the Delhi High Court, on a case asking for FIRs or for action against Anurag Thakur and Parvesh Verma, said, if something is said with a smile, then there is no criminality. Now, even those against whom the state has grudgingly had to take action are booked on much milder charges, like Yati Narsinganand, who is accused in the Haridwar hate Sansad case, despite being an organizer for an event where calls were made for genocide and for overthrowing of the Indian state using force. He was only charged for hate speech and was given bail in anywhere between 3 weeks to a month. Shockingly, others who took part in this hate conclave have yet to be even arrested, including somebody called Pooja Shakun Pandey, who said we are ready to kill them, indicating Muslims we are ready to go to jail. If 100 of us become soldiers, we can kill 20 lakh of them, not arrested. Someone called Anand Swarup Maharaj. All those democratic governments in Delhi will have to listen to our demands for a Hindu Rashtra. If they do not listen, we will wage a war far scarier than the 1857 revolt. Again, not arrested. So that's the dichotomy. That is what is raising questions of asymmetry, of double standards. Joining us tonight on the debate, we have with us Ashwini Dubey, Advocate Supreme Court, Ranbir Singh Pathania, spokesperson of the BJP, Shadhan Farasat, Advocate Supreme Court, Mihira Sood, Advocate Supreme Court. Thank you all so much for joining us. Let me just start with you, Ashwini Dubey ji, that what do you make of this when one looks at these instances? And I've said it's no one's case, certainly not mine, or this shows that people should be incarcerated in perpetuity, but it's this double standards that people who make openly insightful comments, because they're seen as part of the current ruling establishment or its ecosystem, get far different treatment to the others?
Thank you very much for having me here. Please allow me to speak for 50 seconds. The Indian judiciary is very independent, transparent, and based on the principles, the evidences gathered, exercise the discretion. Now coming to the point, here what respectfully, Srinivasanji, you are asking for the parity of two different cases. The parity in a matter where bail has been granted in Bulli Bai case, and subsequently in a case where the anti-terror law is being under trial and people are being framed.
No, I made a distinction.
Bail is
I made a distinction.
Because once
I'm making a distinction here. Yeah. Hold on, I'm going to let you speak, but I have to first correct the impression that you're giving that I'm equating the two. I'm not. I'm saying that in instances where people have given hateful comments which merit stronger charges, like the Haridwar hate mongers, who are essentially calling for the insurrection against the state using violence or genocide, have only been charged with hate speech laws, while others who've also made speeches, like in the Delhi riots cases, where again there's no clear evidence of making such inflammatory claims, they have been charged under UAPA. So there you straight away have a dichotomy, and this doesn't have to do with the courts. This has to do with the investigating agencies, with the police, which comes directly under the state. So you cannot rule out the possibility of political bias and political interference.
See,
that's the distinction.
Once the Supreme Court, under the monitoring of the Supreme Court, evidences are being evaluated, the Supreme Court is examining the issue. We cannot say that there was a political bias. The Supreme Court, being the custodian of the Constitution, in each case, when it is said that there is a political influence or bias may happen during the investigation, the courts take up the investigation.
Can I ask you something?
Can
I ask you something? Can I ask you something? Why did it have to go? No, but hold on. Just answer this question. You said the Supreme Court is monitoring. May I ask why that was even necessary in a case like Haridwar? Why did it have to even reach the Supreme Court for only one arrest to be made? Doesn't that already indicate the ground reality of what is going on?
When it appears to any citizen of this country that the people who are the political powers are people sitting in power may influence the investigation, each citizen of this country has a right, constitutional right, to approach to the court of law. Now coming to the
Shadhan Farasat, now I have to move on because I have others waiting, and in all fairness I must rotate the strike. Shadhan Farasat, what do you make of this argument that the due process of laws being followed? How can one claim there is bias or asymmetry?
Yeah, so I think there are problems at 2-3 levels. Number one is, what are the charges which the police invokes? So that discretion by itself can be applied in a discriminatory manner or in an asymmetrical manner, and it is happening. We are seeing this. You gave enough examples in your introduction. It is happening across the board.
No, second, but you also give examples. What do you mean? For example,
in the Haridwar hate speech case, it's a case which is a call for genocide, is also genocide under the Genocide Convention. India is party to a genocide convention. So please look at how serious what was stated. And what were the provisions which were invoked? Only 153A and 153B, punishable maximum with 3 years imprisonment. Normal, regular hate speech. Why was UAPA not invoked? They were saying we will kill. The statements made were we will kill for religion. That was the level of statements which were made, and UAPA will not be invoked. What kind of a police force is it? So the beginning point itself in a lot of these cases is asymmetric. The police is obviously soft pedaling against certain people and going all out even when case is not made out. Even when case is not made out. So that's number one. Number two, once you invoke certain provisions in a FIR, whether to exercise the discretion or the requirement under law to arrest, there is asymmetry at that point as well. So the second asymmetry arises after you invoke certain provisions, whether to actually arrest or not.
Right.
And then the final asymmetry, which now a pattern is emerging, is also at the level of courts. Some of that, the kind of commentary which we are seeing, it's unfortunate, and really as somebody who's a part of that system, I feel quite sad that if you commit a hate crime with a smile on your face, that is ground enough not for it to be a hate crime. Can you murder with a smile on your face? Will that not be a murder? So
okay,
I think that kind of, when we see that kind of reasoning coming out from courts,
right,
I think it's a little, it surprises all of us who are trained in constitutional law and criminal law.
Okay, let me get Ranbir Singh. Okay, Ranbir Singh Pathania, how would you like to respond to that? That if you have a situation where in Haridwar, despite calls for genocide being made, despite openly saying from a public platform, we will overthrow the Indian state, forget the fact that only one chap has been arrested, that too under mild hate speech charges, all of the remaining are roaming free. Now you tell me that this has nothing to do with the fact that this is a BJP run state and therefore these people have had a soft approach?
Sir, I differ, sir. Not maybe a BJP run state, but this is a state which is being run by the very concept and the very dogma of the rule of law.
So why are these people, why have they not been arrested?
Sir, I'm coming to, you see, we cannot paint two pictures with the same brush. The case we are referring to, that is under Unlawful Activities Prevention Act, that is it, and section 15 of the Unlawful Activities.
No, I am asking about the Haridwar case. Why have those people not been arrested to date?
Sir, you see, I am not spokesperson for the concerned SHO as to why he is not arrested. I am not aware as to what are the ultimate facts which might have led to the arrest or non-arrest of the person. My respectful submission, we cannot treat. I am in full consonance with Mr. Dubey Saab and in full divergence with what Mr. Shadan
Farah, yes.
Mr. Shadan Saab was saying, sir. We cannot paint two cases with the same brush.
I am asking a different question. I am not saying that you are comparing two things which nobody is comparing. We are talking about when you make a speech saying armed insurrection against the state, you don't have to have a long seminar on it. You have to straight away go and arrest the person. Now I'll put the visual. I didn't want to put it because I'm not getting a clear. There is a picture of the Chief Minister of Uttarakhand with one of these hate mongers. Let us put that picture on the screen.
That doesn't.
The Uttarakhand Chief Minister is taking the blessing, touching the feet of somebody who has said, I will wage an armed insurrection against the state.
That doesn't condone or aggravate the offence. That doesn't condone or aggravate the offence. You see, there are some laws we could say as Unlawful Activities Prevention Act. We see section 43D5.
You don't think this comes under that?
Inbuilt mechanism.
No, I'm asking you a simple question. You don't think if somebody says, I will overthrow the state through violent force, you don't think that you don't think it invokes, one second, you don't think that invokes UAPA? Yes or no?
Sir, my respectful submission is section 15 of the Unlawful Activities Prevention Act, which defines a terrorist act. So,
is it not a terrorist?
I don't know.
Is it not terrorist to say, I will overthrow the state?
Sir, I am not privy to as to what material was available with the concerned SHO.
Right.
I am not privy to, but please don't equate both unequal cases.
Okay.
One is a case under Indian.
One is not even drawing that parallel which you are not able to see.
One is not a case under Indian Penal Code.
Okay.
Other one is a case under Unlawful Activities Prevention Act, sir.
Okay,
the Unlawful Activities Prevention Act has an inbuilt mechanism for preventing bail.
Sir, your argument is.
Jail is the.
Okay, I need to move on. Meera Sood.
Jail is an exception and bail is the
rule. Okay, Pathania Saab, can I move on?
This is not
Meera
a
Sood, yes.
Principle, sir.
Yes,
this
Meera
is not
Sood.
a cosmopolitan principle, sir. This is not the hard and fast rule.
Okay, I don't want to lower mic. Pathania Saab, you're not stopping. You're on an uncontrollable monologue. Yes, Meera Sood.
I think to respond to what Mr. Pathania was saying, talking about not painting two cases with the same brush. I mean, take some of the examples you've given. They've said, saying, for instance, that we can do a chakka jam and cut off the northeast from India if we were to get together. How is that very different from what this person was? I mean, how is that worse than somebody saying if 100 of us get together, we can kill so many Muslims and we can establish a Hindu Rashtra? I mean, you are literally advocating group tactics for vastly different means. One is illegal and one is not illegal. So when you say don't paint cases with the same brush, first of all, the entire topic of this show is double standards. Secondly, we are talking here of cases
disputed.
Not even where the cases are similar. but the cases in which bail has not been granted are in fact far more benign than the cases in which bail is granted, or the cases in which arrest has not been made, or the cases in which charges are framed under far lesser sections. Okay, it doesn't serve your argument very well to say that's different because that's a case under UAPA. The question is, why is this not a case under UAPA? Right?
Exactly.
To which your only response is you are not a spokesperson for the police, which is no response whatsoever.
All these, just again to remind, what did Anand Swarup Maharaj say? All these democratic governments in Delhi will have to listen to our demands for a Hindu Rashtra. If they do not listen, we will wage a war far scarier than the 1857 revolt. Saying this from an open platform, and instead of booking him, he's not even been arrested. You're talking, Mr. Patania, of comparison. There's no comparison here because this gentleman has not even been booked.
Comparison is in the favor of the argument that you are against.
No, that's what I'm saying. Mr. Patania and Mr. Dubey are saying comparison. For starters, these people should have been arrested.
Mine and Mr. Farasa's arguments
could have been debated later. It's an extraordinary situation we've come to. Okay, can I ask Ashwini Dubey ji? 1 second, Mr. Patania. I'm not on you. Mr. Patania, you'll have to wait your turn. I don't want to lower mics. This is something we don't like to do. Dubey ji, just look at again the point made about what the court said when finally, because now Parvesh Verma and Anurag Thakur, 26 months after making speeches like Desh ke gaddaron ko goli maro sal, this is a union minister making such a speech. Straightforward case, there should have been action against him. No action. Instead, 26 months later when the petitioner moves court, the court says, if something is said with a smile, there is no criminality.
Correct me if I am wrong, but allow me to complete for 50 seconds, Srinivasanji, with due respect. First point, again, it is not the attempt to raise fingers on the independent, unbiased, transparent judicial system of this country which has granted bail to the Pinjra Tod activist. Point one. Point two, while can the cases invoked under the UAPA be equated with the other offences of the general in nature? Point number three, while granting bail in a case like UAPA, the first thing which is considered, I just requesting for 50 seconds.
No, but the 50 seconds or whatever,
first thing which is considered
10 seconds has to be in response to the point we're on. You're repeating yourself. We are not on that. I am asking you, union ministers and MPs make such insightful comments. This is what the court has to say. If something is said with a smile, there is no criminality. You're a lawyer. You accept this logic.
As a student of law,
you accept this logic.
As a student of law,
yes.
If it appears to the investigating agency that from any of the statement made, there may be disturbance of public order.
Right.
There may be the disturbance of this peace, then of course the case can be invoked, be it the central minister, union minister or anyone.
I am asking you,
in the situation,
I am asking you as a lawyer, you think a union minister from a public platform saying Desh ke gaddaron ko goli maro salo ko does not disturb the peace? Yes or no?
Srinivasan
yes,
Sahab,
sir, yes or no? I have to move on.
Srinivasan Sahab, जो गद्दार होंगे, गद्दारों को ऐसा कहा जाता है, but not the citizen of this country. How can equate that with the citizens of this country?
I see. So you are saying it is justified. You are saying it is justified for a minister to make statements like that.
I again said, don't put your words in my mouth.
Then what are you saying? I asked you yes or no. Will it disturb the peace or not?
Saying it is the discretion of the court. It is the discretion
I am asking you for your view. I am asking you for your view. I am asking you for your view. You have an opinion on everything. On this, you have no view.
No, I
have to move on.
Because reason being the matter is sub judice one.
I see, sub judice. I see. Okay. Shaban Farasat, what is the way out? What is the way out here? If we are going to see this kind of asymmetric response, what is the way out?
Yeah, so I think what is being followed these days is show me the face and I'll show you the law. So, the application of the law will depend on who has committed or not committed a crime. I think one way, of course, that's why the whole judicial system is that you have constitutional courts and courts with substantial power under the CRPC, including the high courts, to ensure these kind of partisan prosecutions are not conducted, or partisan non-prosecutions are not allowed. So I think the courts have to act, and when petitioners and people who are impacted approach the courts, they have to act with speed, because sometimes if things get delayed, like in this Anurag Thakur case, even the hearing now is happening almost after 2 years of the incident, right? These are all February 2020, February 2021 2020, February, March, we had 22. So for 2 years, effectively, there was not even a hearing. So I think time-sensitive nature of these hearings, effective hearings by constitutional courts, high courts, and if necessary, the Supreme Court should be conducted. And if they play their role under the Constitution, I think these errors can be rectified.
No, but if the court is saying something like, if you smile, it may not be hate speech, what are you going to do in that situation?
So I guess if you have individual cases such as this, then you appeal that order and you hope that a higher court will correct such an obvious error. We are very much as advocates part of the system, and we just hope that the system works.
That's it.
Patania ji, I want to ask you, because you repeatedly are talking about the courts and we must trust the courts. I am asking you at a basic level.
Sir.
Police, you will accept, you cannot claim that police and investigating agencies are divorced from political compulsions, because in non-BJP states, your argument is exactly that police and investigating agencies are acting under political compulsions, whether it's West Bengal, Maharashtra, etc. So you mean to tell me that in Uttarakhand, these people have not been arrested for no other reason that there is no political pressure?
I put a counter question.
What other reason can there be?
I put a counter question to you, sir. In any case pending involving high-profile people, is political pressure is a condition which is sine qua non for arrest or not, sir? Please, sir, allow me to complete. Please, we should not use certain adjective. With due respect, sir.
What kind of adjective?
Asymmetry, double speak, sir. This India is governed by, we could say, the rule of law.
I'm asking about Uttarakhand and Haridwar. Why have these people not been arrested?
It had shown the face to Indira Gandhi. It had shown the face to such high echelon. There might be a bad law. There might be we could say, a bad decision which we need to appeal in the higher court of law. And simply by saying a person is smiling, that doesn't end.
That was not my question at all.
That might have been a observation.
That was not my question at all. I'm asking for the third time.
Sir, be assured.
If the whole system is so fair and neutral, why have the Haridwar hate mongers not been arrested despite threatening to overthrow the Indian state?
Sir, we could say, keep assured, I want to assure each and everybody, and you too, sir, the law of the land shall be observed in full letter as well as spirit in the entire country, as well as with special reference to Uttarakhand also. And you also keep assured.
Is the law of the land being observed in West Bengal?
Absolutely, in letter and the spirit.
No, in West Bengal is the law of the land being observed?
We had disputed it, sir. We had disputed. Because the comments and the train of the comments, we could say.
So in West Bengal it is being disputed.
There's a dome of political responsibility.
But in Uttarakhand, miraculously the law, we must believe that the law of the land is being followed.
Will be absorbed in West Bengal, will be absorbed in Uttarakhand also.
Okay, Mihir Sood, yes, wants to comment. Okay, Patania Sahab, yes. I must move on. Yes, Mihir Sood, yes. Okay, alright. Mihir Sood, yes.
It would be, sir.
Alright, Mihir Sood.
I think it's important to point out that, the two participants who are speaking, on behalf of the BJP or supporting the BJP governments are constantly hiding behind this veil of respect for judiciary, judicial independence, etc., when our fundamental question is at the level of the police and political interference with the police, which is a question that neither of them have answered at all, let alone satisfactorily. And, coming to also what Shadan was saying, about, the way forward. It's important to understand, I think, and it's important for our lower court judges in particular and for our police to understand. See, it's very vague, vaguely worded, these offenses, and saying something that disturbs the peace of society can be interpreted in many ways. The fact is, questioning the status quo anywhere can disturb the peace or upend the public order. Okay, but if there is oppression, that means status quo does have to be questioned. That does not mean that, in the case of whether it's a Dalit March, Bhima Koregaon or any of that doesn't mean you don't question status quo. That doesn't mean you can't overthrow oppression. Okay. That does mean that you do have to put up with some amount of social unrest, which it is the police's job to protect, mitigate the effects of, and allow protests. Right? Protest is not something that is illegal. This is the land of Gandhi.
Right. Okay. Well, let's see how it plays out. But at the moment, as we said, there seems to be serious questions over the nature of selective application of the law. We'll have to leave it there. Thank you for joining us. We'll come back to the story. Thank you for watching. Good night.